alongside Tosin. For those joining us for the very first time, JB Law and Life Compass, JBLLC, founded by Mr. Johnson Babalola, is a mentorship platform committed to nurturing law students, young lawyers, and professionals through meaningful mentorship, practical career guidance, leadership development, and life lessons. This platform regularly connects members with accomplished legal practitioners and professionals who generously share their knowledge and experiences, while a team of resident faculty members provides continuous guidance and support. JBLLC is built on the values of excellence, integrity, professionalism, respect, confidentiality, and continuous learning, with the goal of helping every member grow both professionally and personally. Today's mentorship session focuses on a subject that lies at the very heart of a legal scholarship and professional ethics. The name of the topic of today is Credit Where It Is Due, Citations, Quotations, and Intellectual Honesty in Legal Writing. This is undoubtedly a topic that will sharpen our writing, strengthen our research skills, and reinforce the importance of academic and professional integrity. So I encourage everyone to please remain attentive, take notes, and actively participate during the question and answer session. Once again, thank you very much for joining us. And please, for this session, I urge everyone to please mute their microphones until when necessary, and also try to turn on their cameras to ensure participation. Thank you. So without further ado, we'll now proceed with today's program. To formally welcome our mentor for today's session, Mr. Chinua Asuzu. He is an accomplished attorney and author, Africa's leading legal writing scholar. He's the author of several works, such as 1. A Scholar, Asuzu's System for the Citation of Legal Authorities, 2. Brief Writing Master Plan, 3. Fair Hearing in Nigeria, 4. Judicial Writing, a Benchmark for the Bench, 5. Lexical Luminary, If Not You, Who? And the last being Uncommon Law of Learned Writing 2.0. He is a jurisprudence polymath and scholar activist. He also teaches legal writing at law firms and law schools and at private and public forums. He brings to the discipline of legal writing 3 decades of intensive private learning and 2 decades of extensive public teaching. He's an upright and righteous autodidact, and he is all that. So we are truly honored to have you with us here today. Ladies and gentlemen, please join me in giving a warm virtual welcome to our distinguished mentor, Chinua Asuzu.
Thank you, Sylvia. This Sylvia or Silva?
Sylvia, sir. So you're welcome, and over to you, sir.
Okay, thank you so much. It's a very important topic in legal writing. It goes to the foundation of professional personality. So it's very important for you to have to build a high ethical personality around yourself. So from day one, you are trusted to be honest. If you say something from somebody, you say where you got it from, exactly where you got it from, so that you don't claim ideas. In my own training emphasized citations, so that we actually never were tempted to claim anything as ours, because we wanted to add more footnotes. That was the beginning. Of course, now we know that you don't just want to add footnotes for its own sake. Now, when you cite, you are saying to the reader, I found this source, I read it, and understood it, and I'm using it fairly. So don't cite something you've not read. That's general rule. But when you are forced to cite something you've not read, then you tell that in the footnotes. I will explain how that is done. For example, I'm reading a book by Wole Soyinka, and in the book, he quotes Chinua Achebe. I've not seen the Achebe book. I only read Soyinka's book. So I say, Wole Soyinka, the interpreters, I put on this Ibadan 1978. quoting or citing, or I say Chinua Achebe, which I didn't read, quoted in Wole Soyinka, and I say, and then I put the pin site. You have, remember, keep the word pin site in mind because it's very important in the work we're doing today. Pin citation. You cite and you pin cite. I'm going to explain that word because it's very critical, especially in case law citations. And when I say case law, that reminds me that a lot of lawyers and law students say case laws. There are nothing like case laws. The word case laws is not an English word. Case law is not a case. Try to understand that. A case is not case law. It's not a case law. Case law is the law gathered, principles gathered from various cases, which means that you don't speak of case laws. If you mean a case, say case. Don't call it, never call a case law, a case law. So case is not case law is not a countable noun. I hope that's clear. So you never talk about case laws. Every citation makes 4 promises. The source exists, you consulted it, it supports the proposition, it remains fit to cite. Now, it's not enough that the source is here, you read it. Is it even relevant? Is it pertinent to the point? So that's the number 3. It must support the proposition, it must be relevant. If it's a case, it must be useful in the sense that you are driving from the ratio decidendi. It remains fit to cite. This needs explanation. For example, if I'm drafting an article now in August 2026, and it takes me 3 months to draft the article. Now, in August, September, I've added citations, quoted cases, quoted articles that I vouch for. Then I want to submit the article for publishing in November 2026. Before I do that, I go around the footnotes, the bibliography, to see whether everything I cited is still good law. That's what we call shepherdizing. You shepherdize your articles, your quotations and citations. Confirm if it's a case, has it been overruled? If it's a statutory, if it's a regulatory rule, like rule of court, has there been a practice direction that changed it? In fact, I have a similar experience right now, a book I'm doing. The Supreme Court issued a practice decision that modifies what I had said in my earlier draft. I quickly adjusted. So you need to know whether the source is still sound. The proposition you draft from the source is still sound. And you shepherdize your authorities. So know that word, shepherdize. SHEPARDIZE. It doesn't come from the shepherd that take care of sheep. That's why I'm spelling it, because it's different. It's somebody's name, actually. So now, citation errors are critical. Don't forget that whoever is reading your work, whether it's a book, article, or brief to a court, we want to look up some of the authorities. When it comes to books, it's a few people that want to look it up, and those guys are serious scholars. They'll be disappointed if anything you've said is not correct. So you have to, especially in case law discussion, don't distort a holding to favor your position. Whatever case you say, you must present it correctly to the court. Don't pretend that it favors you. You must say to the court what exactly he did. So credit is critical. That is attribution. Always see where you got it from. Check your sources. And be careful with things like typography, the language. We're going to see that anyway. Quotations, paraphrase, and summary, they differ. They're all borrowing. If I quote, I'm borrowing. If I summarize, I'm borrowing. If I paraphrase, I'm borrowing. In summary and paraphrase, I'm using my own words, but I must attach a footnote and say where I got it from. Now, look, let's look at this. This is for you to try. And if a brief quotes a striking sentence from a textbook, and the textbook, that means the author of the brief read a textbook. The textbook attributes that sentence to a case which the lawyer never read. Now, this lawyer cites that case which he has never read. What is wrong with that? Okay. If we were in open class, I will ask you to answer, but let's look at the answer together. Look at the example of how it works. The Supreme Court described jurisdiction as the lifeblood of adjudication. Footnote. Let's say that's the footnote. But the writer didn't see the case. He only saw it in a... What he should have done is to go dig up the case and read. Okay? Now, if for any reason he can't find the case, it means when he cites it, he will say, quoted in, he names the book in the normal way, the full citation of the book. Now, if you look at that bullet, second line, that tells you how to cite a case, which is something that is very important for us to know. You will find very few lawyers, less than 5%, cite cases correctly. So those of you who are students, you should enter the profession with proper citation. First is that the year should be in brackets, not parentheses. What we call square brackets. Second, the part, if it's a law report that has parts, should be spelled out in full, not abbreviated to PT. Because I want to be legible to everybody anywhere in the world. Whoever reads we know what it means. If you say PT, some people won't know what that means. Some people will think it's points. Third, the law report name, like NWLR, should not be punctuated. Don't write end of .w dot, because why not? Because uppercase abbreviations that have become well known don't need punctuation. For example, EFCC, NDLEA, USA, UK. When an uppercase abbreviation is well known, we don't punctuate it anymore. So your NWLR should not be punctuated. Your part should be spelled out. Then you put the page where the case starts, 1. After that, in parentheses, SC. Then, comma, the pin site page. This one is not complete because after the pin site page and paragraph 12A to B, you now put in parentheses the justice's name. So this is how to be helpful to a reader. Now, if you're working with me now as my junior associate, I bring me a case that's relevant. I just stop at 1, page 1, SC. You are telling me to go and read the entire case to find what we need. Meanwhile, it might just be one sentence in the case that we find useful. So you pin cite. To pin cite means to pinpoint the citation, pinpoint the relevant paragraph. You pinpoint the relevant paragraph. 12A to B, in parentheses, carry there a short JNC or whoever the person is. Anyway, I see more of it, but it's very important. Okay. Locate and read the case, confirm the words and the context, pin cite the passage. It's only when, if it's not available, you disclose the intermediary. The intermediary in this case is the book that you read. So the reader is entitled to know where the law, language, and ideas came from. Not only entitled to know that, also enabled to find it for himself. Tell the reader where it is and make it easy. Facilitate his checking of your authorities. You don't want a reader just because you read an article to go and read the whole article. So you pin cite. Whether it's an article or a case, always pin cite. It makes your intellectual debt visible. You credit the originator. It's a very broad thought for original analysis. So whether you are quoting it or paraphrasing it, you put a footnote at the end of that, usually at the end of a sentence, at times at the end of a comma, at times at the end of a semicolon. But you must always have footnotes after every broad idea at the appropriate point where you end that broad idea. So you respect reader's time. If you have a book of about 300 pages, that's what I want. I want to read that book. I just pick it up to read it. You don't have to send me to go and be reading innumerable other books. That's why you pin cite. Tell me what you got from that book. Okay, so every citation must address these 4 questions. Who created it as author's name? What source, the book or article? Where exactly is it? This citation? Why does it matter here? Pertinence to the discussion. So I know that by now you all understand what pin citing is. Pinpoint citation. Quotation identifies the speaker of the words. Paraphrase identifies the thinker, because you're not quoting. Why do we say the thinker? Because you are saying in your own words what the speaker actually said. So he's actually a speaker, but since you're not using his words, we don't call him a speaker. Then someone identifies the source in a compressed account. So you simply, something you read in 3 pages could be put in less than 1 paragraph. That's summary of what you're saying. Because you're talking to the reader the way it works for your argument, for your position, what you're saying. So you don't need the entire thing that the original said, that the source said. So that's why when you name the authority, of course, we know that if it's a book, you name first, comma, the title in italics, comma, sorry, before the comma, after the title in italics, you put the publisher and year in parentheses. We no longer need to put the place of publication. So you don't have to say London, Heinemann, 1972. You just say Heinemann, 1972. Or Harvard University Press, 2004. Publisher and year in parentheses. You close parentheses, put a comma, and put the page. If the book has an edition, that should come before the publisher and year. Okay. A starting page identifies a work. Of course, you know that in the case of a book, we don't have pin citing in a book because it's only 1 page we have. Pin citing suggests there are more than 1 page. In an article, you find that it may start on page 37 and go on to page 60. But what I want you to see is on page 44. So I say 37, 44. 44 means the pin cite. In a book, you're only quoting a particular page or range of pages. So books don't have pin citation. For cases, pin citing is vital and shows respect to the judge. You know, because if you are telling the judge, you quote a case to the judge, what do you mean? You want to read, maybe your brief has 25 cases. You want to read them before he can decide. No. But when you use pin cite, the judge knows that you know what you're doing. You're telling him, this case is supported from page 75. If you go to page 94, paragraph C, you see the point I'm making. He'll be very happy and very appreciative of you. Very few lawyers do this. Very simple and very helpful thing to do when you start a case to a court. Always pin cite. In fact, if at the end of this lecture you go away with just pin citing, I'll be happy with you. Okay, it's very important. Then what is a parenthetical? Don't go around telling judges to see this case. See also, don't send judges on errands to see a case. Nobody wants to do that. If a case is important for you, for your argument, either in a brief or in a book or article, if a case is important, discuss the case in much detail, in the detail you need to support what you're saying. The argument of proposition, discuss it in the body. If you now want to say other cases are saying the same thing, if there's any reason for that, often there is not. But if there is, each case you name without discussion, this is very important. Each case you name without discussion, add after the citation what we call explanatory parentheticals. Explanatory parentheticals. We're going to see what it is. Just keep that phrase in mind. Explanatory parentheticals. I'll tell you how it works very soon. Any case you are not discussing in a book, article, brief, judgment, if you're a judge, you must add after the case explanatory parenthetical. Okay? We'll see that very soon. Then this is what I said earlier, shepherdizing. It takes a number of days or weeks to write a brief. It takes months to write a real law article. It takes months. If you finish an article under 1 month, there is not a real law article. It takes months. It may take a whole year to write a real article that's publishable in a good journal. So, meaning the research I did in January, how am I sure it's still good law in December when I'm submitting the article? That way I do shepherdizing. Has it been overruled, limited, criticized, distinguished? If it's legislation, has it been amended or repealed? If it's a rule of court, is there a party direction that modifies what I'm saying that Order 7, Rule 15, or the Federal High Court rule says? Has it been modified in any way by party direction? I have to check all that before submission. So just on the eve of submission, you shepherdize. SHEPARDIZE. Shepherdize your authorities. Now, borrowing ideas, which is part of academic. In fact, it doesn't make you weaker, it makes you stronger. It can be quotation, exact words, compressed account, summary, comparative length restatement, paraphrase, or your own analysis of what that person is saying, which may be like a critique of that. You still attribute. In all of these cases, you attribute by footnoting. Before we continue, let me say something I'm hoping that the profession will adopt. I'm saying that we should adopt footnoting in professional writing like briefs, instead of putting the citation in the body of the work. Judges should use footnoting when they put a case. You name the case in the text and put the citation in the footnotes. Now, what advantage of that is that if you look at our judgments and our briefs, if someone may name a case on line 7 of a page, for example, and then the citations occupy 3 or 4 lines, and then the person may name 4 different cases, one after the other, with citations all over the place. So, and these cases are inside the sentence. So you read a few words, you start looking for where the sentence continues. It's not nice, it's not kind. So I'm suggesting that we should adopt footnoting in professional writing, not just in academic writing where it's already used. And I was very happy to find, because I've been preaching it, and some of my colleagues say, well, that's not good to be sent back to the judges. And I was advising on a brief. I was helping a law firm draft a brief, review a brief. I was arguing with myself, you know what? Okay, I like footnotes, but what if the judge doesn't like it? I don't want to annoy the judge just because I'm teaching that we should use footnotes. Then I saw the other side's brief, the other side, and they use footnotes. So I now say we can't suffer any privilege, any prejudice by using footnotes, if both sides have done the same. I was very happy to use footnotes in that case. I think you can use footnotes, okay, for your citations. Now, of course, we all know quotation marks. Use double quotation marks and make sure that curly quotation marks, not straight quotation marks that look like inches and feet. They must be curly or smart. What we call, I think I have it somewhere below. Use curly quotation marks, double quotation marks for main quotations. Now, if you have a quotation within a quotation, that quotation within a quotation will be in single quotation marks. If you have a block quotation, which is indented passage, don't enclose that one in quotation marks. You don't use quotation marks for block quotations. And don't italicize your quotations. Stop italicizing your quotations. Don't use bold, don't use italics, don't use all caps. Now, for cases, the only way we distinguish cases in good legal writing is by using italics. Stop shouting at the reader with a bold face and all caps or underline. Don't underline anything again in any kind of legal writing. At the end of the paper, I want you to ask me a question about underlining. Why you should stop underlining whenever you write anything. Don't underline anything unless you are writing longhand. If you are typing in a law office, nothing should be underlined. If it's the heading of a letter, put it in boldface. The heading of a court document, a motion of notice, put it in. Now, this is just another test that I think we can jump because, okay, let's jump that because. It's not everything that you must cite. If it's borrowed, of course, you must cite. If you are going on appeal and you synthesize the record, it's not every word you use or every sentence that you just cite where the idea, where that event happened in the record. Okay. If something is generally common, if you say Paris is the capital of France, you don't cite, even if you read it somewhere. It's generally common knowledge. Usually uncited, publicly settled facts require no specialist source. Usually cited legal rules, contested facts. Because I want to show that, for example, in an appeal, you want to show that it's there, it was there in the record. Statistics, if you say 75% of Nigerians are doing something, you must show your source. Distinctive ideas and borrowed formulations must all be cited. Citation cannot replace the missing logical link. You must state a proposition. In fact, preferably, state it first before you refer to your source. Now, in legal writing, especially advocacy, avoid beginning paragraphs with cases. Don't start a paragraph with a case. Each paragraph, you start with a thesis sentence. You are talking to the court. You are proposing to the court. You are propounding to the court. You must be the one saying something. To cite a case, you have said something. Then support it with the case. Don't let the case talk for you. Take command of your briefs. Take command of your arguments. Take control of the. You are helping the court to make law. If you are upheld, you are indirectly making law. Can you hear me? I'm sorry, I got disconnected for a minute. I don't know whether you can hear me. Can you hear me?
We can hear you, sir.
Okay, good. Can you see my slides?
Yes, sir.
Okay, excellent. So don't let the cases talk for you. People overemphasize cases. It starts from law school and the university. They keep telling people case. You know, it's not cases. You must think. You must tell the court what should happen. So after saying that, so the first set of a paragraph should be what you are saying. Of course, that thing you're saying may have been derived from a case. No doubt about it. But it must be in your own words. It must be a proposition of law. Then you now support it with authority. For example, let me think of an example. The court will allow a party to introduce evidence that was not available to the party at the beginning of the case. Period. In support. I'll explain how it applies. That's what we call citation signals. Let me see whether I can how they work. Citation signals. For example, C. People say, C, if you are citing a case, if you make a statement, provision of law, I will cite a case directly on point. You don't need to say C. C is like, okay, some other thing might help. If it's directly on point, you just put the case. So I think this is the case. C is like, okay, you look at it, my lord. You'll agree with me that is useful. Okay. You form the habit of very strong curiosity, looking for the original source. Where is this from? Who said it? Where? So that if you're reading a Supreme Court case or any case at all, and you find a very important point that they held, but in so doing, you are referring to another case or a book or an article. Your curiosity should lead you to go and read those things. There might even be a mistake. So you decide whether, if you read the article, you decide whether for your purposes, you want to cite the Supreme Court case or go to the original. Because if the Supreme Court case does not favor you, you might show that that's not what the original said, and the decision was a per incuriam. So find out what happened. Dig into the history. We know that in law we have hierarchy of authorities. Primary authority, secondary authority. Primary authority, constitutions, legislation, subsidiary legislation, cases, and treaties are domesticated. Then secondary authority are commentaries on the law, books, articles, and so on. You know that, of course, primary is ordinarily better for you. You are talking from the statute. Legislation is higher than cases. I hope you know that. Constitution comes before cases, statutes, and statutes come before cases. Statute is direct language of the law. Cases, although they are primary, they are interpretive rules. Okay, I'll just over this. Now, another very important topic that we should talk about, head notes. Where if you open a law report, if you open a case, after the first few pages, you say, after facts and procedural history, you see held, 1, 2, and so on. Do not rely on those head notes. Never, ever rely on them. Why not? They are the law reporter's summary of the decision. And they point you to the body of the judgment, to the very page and paragraph where the justice is talking. Why would you be reading something about what somebody else said when that one is available, when the original is available? So use head notes to point you to locate the passages that you want. They should not exceed 1 page. I don't know why the law reporters are writing 5 pages of head notes. They're deciding the law for us. Law reporters have no mandate to tell us what the law is. So they only point you to the pages where the Supreme Court or whatever court is talking. Why? Don't even read the head notes. Only browse them to know where to go and read. And never quote from head notes. Never, ever, ever quote from head notes. So like I say ratio 7, ratio 3. Why would anybody else tell you? Why would somebody somewhere tell you that what the ratio of a case is? Nobody has that authority. Those who are law students in this room, please, 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 never quote from head notes, never refer to them, never do anything with them apart from using them to locate. They are just GPS to help you find where the court is talking. So don't be a head note lawyer. Your research in case law begins where the head note points, not the head note itself. These are summaries. They're editorial summaries. That's what they are. So don't be a head note lawyer. We've said this already. We've made this point already. I should try to locate the original okay. So if it's quoted, you say quoted in. If it's not quoted, if you just refer to, you say cited in. I think I have an example. Okay, let me see. I think I have an example here. Okay, I think I'll find it later. Mm-hmm. Okay, I think I have an example here. Okay, I think I'll find it later. Mm-hmm. Okay, I think I'll find it later. Okay, I think I'll find it later. Mm-hmm. Okay, I think I'll find it later. 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 Okay, I think I'll find it la Intermediate source, the one I'm reading. What I have here is a book by Richard Posner. I'm reading it. But inside it, on page 77, he's citing Lord Denning or Brian Garner. I don't have that one. I can't find it. So I must confess to the reader. Say, this is quoted in. So that source is quoted in is the one I read. So reader is entitled to know that what I've just quoted, I don't have it. Or what I just cited, I didn't read it. One of the advantages of that is, apart from being ethically right, it also enables the reader to even check. What if there's a mistake? What if I'm wrong? And so on. You have to, for everything you do, you have to think on the possibility of being wrong, even when you're sure you're right. Yeah? So the reader has to have that judgment made for him. I can't be the one to tell you that I'm sure of what I said on page 75 of my book, because I'm not the right person to say so. I'm prejudiced. So I have to enable you to check it. I must enable you to check it. And I'll be happy to enable you to check it. I'm actually sure of my sources, but I must let you check. Okay? So if you find the original, you forget the intermediary. I'm reading a book by Richard Posner, quoting Lord Denning. If I can find the Lord Denning, I forget about Posner. Even though that's the book I have. If I can find the Denning, I open it and read it. If I can't find the Denning, I disclose both. Let me see. This is a very good example. DIFF1, Principles of Civil Procedure in Nigeria. This is a rare book by a law lecturer in Nigerian Law School. Snap Press 2013, 5. Now, I didn't read F1's book. I don't have it. Right now, where I'm sitting now, I have CU Mozoba, Civil Procedure Illustrated, Snap Press 11 to 2. I have that book right now where I am. And that's what I read. But what I read that I need in my work, he attributed it to a favorite one. So I must confess, quoted, yeah, I'm citing this guy, a favorite one, whom I never read. At the end of the quotation, after 5, comma, I said, quoted in, and if you go and look at it, you see it. I've not even seen this guy's book. I've not even seen it. So the reader must be told that. In your bibliography, you list both books because they're useful. If I didn't quote, if I just referred, then I say cited in. Yeah. Okay. Okay. If you are quoting a passage that has a footnote inside it, you don't use that footnote marker should not show up in your own quotation. Although the rule of fidelity to source, which is critical in academic work and legal work, does not extend to footnote markers. The rule that you should be quoting verbatim, except for when we make changes with brackets or sake or ellipses, doesn't extend to footnote markers, those superscripted numbers. Instead, you at the bottom, you say citations omitted to show that you didn't include the footnotes. That's what it means. It doesn't mean that you omitted citations. It means that you omitted citations in the original you are citing. If you italicize, of course, I've said before, never italicize a quotation just because it's a quotation. You're italicizing one or two words, 3 words at most. A short part of the quotation. You have to indicate whether those italics are in the original or you supply them for emphasis. If you're the one that supply the italics mine, then the original, that's in the footnote, of course, not in the body where the italics appear. At the end of the citation, you say in parentheses, italics mine, italics in original. If it's okay. Because of the time, I'm jumping all the exercises we would have done if we were okay. That's what the point we made. to match each proposition to the party that genuinely supports it. Okay. Mention. Let me see what other points are very important. Yeah, just a minute. Let me see some other things I want to say that are not on the slides. Okay, this is what I was saying about pin citing when you quote case law. At the end of the citation, after naming the page where the case begins, and in parentheses, SC, comma, 264G to H by JJC. Alioke and Oye, that's italics, the year in brackets, NWLR not punctuated, the part spelled out, the page where it starts, and the pin site. The under 6 is what we call pin citation. Very important. Supposing you are working, you're a 25-year-old lawyer assisting a senior advocate who is extremely busy with innumerable cases. He wants authorities on the party, but you send it to him without pin site. You send him about 7 cases to read without pin site. You are punishing the poor silk. He wants to know what passage. When he sees this one now, he will increase your salary. 264G to H. You are telling him to read a few lines in the whole case. He will raise your salary. That's the way to do it. This is without pin site. Supreme Court. Okay? So that was saying that pin site shorten the reader's journey. Starting page identifies where it reports, pin pipes and marginal letters, locate it. That's it. Very important. Pinpoint citation. That idea of pinpoint citation or pin site should be something you should go away with. Critical. And then avoid head note lawyering, which is malpractice. Now, I spoke about, just a minute. Okay, these are still about head notes. I wanted to go to where we talked about explanatory parentheticals. Yeah, these are examples of, you made this statement in your own words, you cite and pin cite. Okay. As I said, C, it must indirect support. If the support is direct, don't put it, just put the case. At times we say compare with string cites. A lot of lawyers are fond of string citation. That means multiple authorities for one proposition of law. Use one authority if it's sound and good and you may use two, but one is better. If you have good reason to use multiple, either because you are saying, for example, that a case that has been, different for here and there, there's a lot of authorities that support that case, that position. Or citing foreign case law, I find that India Supreme Court, Kenya, you have persuasive authority now. It's a bad case, it's a tough case, it's sitting on thin ice. You find that UK Supreme Court, Kenyan, Indian, Canadian, US are all saying the same thing, which favors you. That will justify a string cite. But otherwise, minimize string citation. Use one authority or at most two. Yeah, that's examples of when first impression, for example, will justify since present to show how the court should analogize to the present case. Then we now go to explanatory parentheticals. For any case you don't discuss, I've said before, don't tell a judge to go and see. Discuss the case and share what it does for you, how you are winning with that case. If you name a case you don't discuss, use either explanatory or quoting parentheticals. Better use your own concise account, beginning with a participle, holding, upholding, analyzing, discussing, distinguishing. These are participles you use. Quoting parentheticals, take the exact word from that case. Let me see what I have example. These are the typical participles that begin parentheticals: affirming, construing, distinguishing, and so on. Okay, look at this example now. You are not discussing mobile oil in your brief. When they come to see it, you cite it. That's the NCLR word, SC, Supreme Court, comma, 13. That's the plain site now. Bello JSC, in parentheses, affirming the utility of the BC rule in interpreting tax statutes. That encourages the judge to check out the case. Because, for example, if you look at the context, in tax lawyers will tell you that the only thing that matters is only the literal rule is used for tax law, for tax statute interpretation. Every you meet any tax lawyer, say, literal rule, nothing should be ready, no golden, no interpretation, no purposive. But I dug out this case, ancient case, before you were born, that says the chief rule can be used in interpretation. That destroys the 5 decades of blasphemous jurisprudence that Nigerian tax lawyers have been propounding, that only literal rule can be used to interpret tax issues. If you know tax law, you'll be familiar with Cape Brandy and Duke of Westminster, 2 cases that canonized this wicked principle. So you need to know how to use your parentheticals. Okay. Legislation is typically quoted in text, although there are situations where you also use footnotes, but are often quoted inside the text. Yeah. Just as I said, that you should not say in the case of, you just say the case. Also, in citing statutes, not say the provisions of section. The section, that means the provisions of that section. Section. And if you are drafting contract or statute, and you are inside a section, don't refer to subsection 1 of this section. Say subsection 1, because that's about this section. Okay. Others, we know that already. Rules. There are other things there are so many things to do. How many minutes do we have? Sylvia? How many minutes do we have? I want to know how fast to move. Okay. Let me go on if you think. Minimize quotations in legal writing. Minimize quotations. The document should be mostly your own thinking. So that's why you need to minimize quotations. Okay. Quote sparingly. And when you quote as few words as possible. And use substantive lead-ins to your quotations. Don't say according to, or the Supreme Court held that, say something, a lawyer always has an agenda, and a lawyer must pursue his agenda. You must have, in other words, it must be strategic in your writing. You will choose every opportunity. If you are citing statutes or case law, introduce that citation with language that favors you. For example, if I'm representing the governor of Lagos State in a case where acquisition is being challenged, I say, Section 17 of the Land Use Act empowers the Lagos State governor to, I quote. All I need is that provision to quote it. If I say Section 17 provides, I'm not doing anything. I'm being neutral. I'm using provide is a neutral verb. Don't use provide when you are quoting statute. It's a neutral verb. You're not neutral. Say what it does for you. Section 17 empowers, enables the state governor to do this. Section 17 limits, if you are on the other side, the 17 limits the governor's power to do this. Restricts. So you must always introduce your quotations with language favorable to your side. Don't use neutral verbs. Don't use neutered verbs. Use advocacy language. Very carefully. Okay? Block quotations need a leading. Every quotation needs a leading, but block quotations need special formatting. Leading, space, one line space, then in the indented passage. One of the ways of formatting block quotations is that apart from the indentation, which is 2.54 centimeter on either side, on both sides, that is 1 inch space on both sides, number one. Secondly, smaller font size than the body of the work. If you're using 13 or 14, if you're using 13, for example, Century School Book, 13 point, you go to 12 for your block quotation. Then single spacing. Generally, your writing will not be, the body of your work should not be single spaced. Maybe 1.2, 1.5. Never more than 1.5. Unless the cut rules insist. 1.2, 1.3 for the body of your work. Then indented passages, single spaced. There must be leading and lead out. You can't just leave a quotation and go to another topic entirely. You must say something about what you've just said, what you just quoted. Of course, we have said don't use quotation marks, don't italicize any quotation because it's a quotation. Okay? Know how to accept, graft words that you need from a long passage instead of taking the entire passage. Yeah. In using ellipses, it must be obey the rule of fidelity to source. The reader will assume that what you are connecting with ellipses, we are close together in the original. So I shouldn't take something from page 17 of somebody's book, put ellipses, and complete the sentence with something from page 77. There must be something parts that are apart and in the same context, so that you retain integrity. Of course, ellipses, you know them, of course, 3 dots. It must be genuine ellipses, not any 3 dots, because if you use any manual 3 dots, if it comes at the end of a line, one might go to the next line. But if it's a genuine ellipsis, it doesn't do that. You use square brackets to mark your own interventions in the quotation. For example, when you change capitalization or insert explanation, yeah, we've seen this already. Let me pause for questions. I don't know what time it is. I'm not looking at my watch. I think we're almost done. Okay, we're almost to the end of the lecture. So if you have questions, this is a good time to ask it.
I have questions.
Okay, please do. Yeah. Go ahead.
Go ahead. Thank you very much. I'd like to, first of all, appreciate the J.B. Babalola putting this forum together, this very robust presentation, and continue to bring us a distinguished personality like you.
Thank you.
It's a privilege that I have read some of your articles. I don't know where I found them, but I've read them somewhere with Ulisa Gbokpoba, Michael Zekome, and come across a lot of your. I'm very proud of you.
Thank you so much.
As a Nigeria, you have actually shown. I don't want to be seen to be celebrating you, but you were celebrating. I'm proud to say I have seen your work, and they are very genuine and very natural to you. They are unique to you. That is what single you out. Thank you very much for this robust and fantastic presentation. However, I'm an author, and I have one big challenge in this area, which you have helped to kind of balance a while ago, but I still have more questions for you.
Okay.
I have read a lot of books.
Yes.
Where you see the author quoting, you can visibly see. If you haven't read those quotations, you may not know. Why? Because some of these quotations are already paraphrased.
Yes.
So I still find myself making the same mistake. I quote a lot of my authors, but I don't really like to be seen to be quoting verbatim.
Yes.
I don't know if I'm wrong. What I like to do is to redevelop your quotation. I don't want to use the word paraphrase. I want to use the word redevelop your quotation and then develop my own.
Yes.
Actually, my first book titled The Quotes of My Father That Inspired Me, I have it. I have to deliberately, when I saw this, it's exactly your presentation, I read it somewhere. I have to deliberately put the names of all the quotations. But again, here is my challenge. There are quotations that were quoted 1950, 1940 something, 1930 something. And then you see them paraphrased by other popular other popular authors.
Yes.
Now, how do you own your own quotation? Here is my question. How do you also distinguish between some of those past quotations that are related to the current quotation? I'll give you a practical example. There's a book by Steve Covey, First Thing First. I read that book many years ago. If you read The Power of Positive Thinking, you will see there are some elements, even though they are not saying the same, but they are interwoven, kind of married. So I'm a bit wondering, I kind of wondering, these are almost saying similar, but in a different way. So how do you own some of these quotations? How do you avoid quoting someone and without mentioning his, how do you kind of escape quoting someone and not mentioning his name, and the quotation goes viral and makes it look as if you are the owner of the quotation? I've seen it happen in a book by two, I don't want to mention their name, by two popular authors in Nigeria, that everyone thought the original author, took it from the other, why the other. So I have difficulty, and I've had a meeting with those two authors, and I found out that he owned up that statement is owned by that author. But I already made a mistake. Because it has gone farther, it can't withdraw it. How do you manage this kind of situations? So I like to also plead with you. This presentation is needed not just by lawyers, by everyone who reads and writes. How do you discern this content to everyone to know, especially students, to know the danger? Because I think there's something you call in law, it escaped my mind now, where, when you copy, is it plagiarism or?
Yeah, plagiarism, yes.
Thank you very much, sir. So when you take a content without quoting the source, or rather, pretending to own it, or pretending to own it, to pretend to own it.
Violation, yes.
So I like to see how, because with all of this whole presentation today, it will save us a lot of trouble. Thank you very much. It has actually helped me to revisit some of my materials and deal with them based on this presentation. So there is need for this information to be properly, I don't know, forum, disseminate more, where we should have more people to have a clear understanding. I must say this in closing, that most of us who do these things are not necessarily aware. We are not aware. Some of us don't even know that it's a very serious criminal violation. That's the word, sir. Violation against, and there are laws in many countries. In this part of the world, for instance, there are laws that when it's invoked, okay, I did something, I added something I got from Google. I was sued. They took me to court. You know, but thank God for friends who had to come to my rescue and then get me out using where the company was registered to where that incident took place. Again, let me thank you in closing profusely, and thank you very much for the work you do and for being available to continue to teach us. May God continue to increase you and bless you on every side. So please look at the ways of ensuring that this thing can reach more people all across the world. It's very helpful, and it has helped me too. God bless you. Thank you.
Thank you so much. Amen. Thanks a lot. Thank you very much. Yeah. So it's vital for any writer, any researcher, when you are still researching, to make very detailed notes of your sources and attribute properly. Whether you are quoting or paraphrasing, always attributes. And then secondly, use people who are credible in your research. Who the hell is the person talking? I saw a book on Amazon about PhDs. I had to investigate the guy before reading his book. But for example, what you just said now, if I quote someone who stole from somebody else, someone might think I'm the one stealing or not attributing properly. Because I would, of course, I would quote that guy, but it wasn't his own idea. So I'm now attributing the wrong person. I don't want to make that mistake. So if you read the correct authors, credible authors, you be very careful what you quote and where you paraphrase. I mentioned curly quotation marks. If most computers, if you type quotation, it will show straight quotation marks. You have to go to your computer and go to your Word, go to insert symbols and locate how to choose the option of curly quotation marks. Use straight quotes only to represent inches if it ever happens to you, because in law business we don't do feet and inches, but if you do, you can use straight quotes. But these are curly quotation marks. Double ones for main quotations, single ones for nested quotations. That is quotations within quotations. Okay. Apostrophes must be curly too. Don't use straight apostrophes. Use curly apostrophes. Okay. Articles take single quotation marks. Title of articles. Unlike title of books, which are italicized. Okay. That's the way it works. Now, because block quotations don't take quotation marks, if you have a nested quotation inside a block quotation, that takes double quotation marks, because there was never a double quotation at the beginning. And so on. We've said this already. You don't have to repeat the footnote markers. Okay, that's that about that. Although we still have some slides to go, I'm thinking maybe you are tired or bored and I have other things to do. So maybe if we can close down, that's a good idea. Of course, I have a lot of things to say, but we don't have all the time in the world. I've discussed.
Thank you very much, sir.
Yeah, great. Excellent. Yeah.
Thank you very much, sir, for such an enlightening session.
Okay, great. Thank you.
I believe I speak on behalf of everyone and I say that today's discussion has left us with valuable lessons, especially with regards to legal writing. Thank you very much once again for everything, and we really, really appreciate you. Please, can we clap for give a virtual clap to our mentor for today? Please, a virtual clap.
Thank you. Thank you very much, everyone.
So please, on this note, I will now invite Asiwaju to give closing remarks.
All right. Thank you very much, the hosts, Sylvia. Thank you very much for ensuring that this has been spot on. You joined the session very timely, and you've been doing a wonderful job navigating the conversation so far. But most importantly, I also want to acknowledge Chinua Asuzu for everything you've always done for us. pronouncing that name this night, I felt a bit somehow, but I know that you are not a big fan of attaching titles to your name, so I wanted to respect your choice as a show of respect to you. So, but while you were speaking, you said maybe we are bored, or no, we are we are not bored. In fact, most of us have our notepads here. We are busy writing. It was doing us as if we should just steal the slides away from you. But even the perspective that you are sharing, there's no way we could have stolen that away from you. If you want to take maybe some extra 5 to 10 minutes, if you are kind enough to maybe still show us some parts you think might be relevant, we know that if we are going to pay for sessions like this, it will be very, very expensive. We are going to gladly take that opportunity. So except you have something you want to pick up urgently, I know I'm speaking on behalf of everyone that we can take 5 to 10 minutes. I know our mentor, Mr. Joseph Babalola, already acknowledged that this teaching is different. It's not the regular kind of teaching. So we should make an exception. So please, if you would be kind enough to still take us for an extra 5 minutes, whatever we're able to pick that 5 minutes, we see it as the icing on the already cake that you have given to us. So we will not take the closing remarks yet. We'll still do some extra 5 minutes with you, sir. Thank you very much, sir.
Okay. Why don't we have a conversation during the 5 minutes? You can ask questions. I'm sure you can ask questions that any question that has to do with citations in legal writing, how cases. Okay, let me say something about formatting in legal writing. That's something that's very common in legal writing. Since you guys are young lawyers and law students, you don't join that crowd just because you see it maybe in your law firm, or there's too much emphasis in legal writing. When you emphasize too much, then not everything is lost. Emphasis is lost. Boldface, when you write, whether in legal writing or anywhere else, don't throw a lot of those magic at the reader. Boldface, italics, underlining. Don't underline anything in legal writing. The whole idea of underlining was for the typewriter era, because on the typewriter, you couldn't do italics. So you use underlining to simulate italics. Now, cases italicized, title of book italicized, heading of a paper bold. Also, minimize all caps. Use all caps only where they are so established. For example, in cases, we say in the case document, processes, court processes, in the High Court of Lagos State, that's capitalized. In the Kenya Judicial Division, that's capitalized. Sitting at the Kenya, that's capitalized. After that, everything should be normal case. Not capitalized. Don't throw capitals at the leader. So minimize capitalization, minimize emphasis. It doesn't work. It annoys the judges. Make your points quickly and move on to the next point. And the judge will see your point. It's not by shouting, by stylistic formatting, screaming at the judge. Okay? I see some raised hands. Let's go there.
All right, thank you very much, Sylvia. You can coordinate this part. Let's take 2 questions that are very, very straight to the point, and then we'll take questions from the chat box so that we can bring this to an end and save our prof some time. Sylvia, are you there?
Yes, sir. Okay, sir. So I see 2 hands already raised. So please, Nathaniel, please, you can proceed with asking your question. Please unmute and ask your question.
Yes, good evening. Sorry, can you hear me? Can you confirm you can hear me, please?
I can hear you.
Okay, thank you very much, sir. I'm very grateful for this session. I'm Nathaniel, a 400 level student at the University of Jos, and I want to ask particularly for students, or I would say particularly for writers, being that we are in the era of AI, technology, and the rest. I don't know what your view is, sir, in the regards to what's it called? AI aids, that is generative AI aids in researching, that's in research and writing. Where do you based on your own experience, do you encourage using that as an aid for research? And when, for example, anything is gotten from such tool, would there be need for any kind of citation? For example, when an idea is gotten from something like that, from an AI tool, right? When it's not practically what you've reasoned out personally, but something you got from an AI tool, would that also require citations? That's my question. Thank you very much, sir.
Okay. First of all, let me say something about AI before I answer the question. My own experience with AI is that AI gives me more work. So now, why I'm saying that is that a lot of students and lawyers, the AI makes their work easier. So that's my concern, that they are outsourcing their work to AI. So I use AI as a research assistant. And what I find is that what would have taken me 3 months to write will now take me 9 months with AI. That's the thing you need to understand. Why is this so? If you're asking why is this so, you are very good right to ask that question. People will wonder, but that should make it faster. No, it doesn't. Because I'm going to be interrogating the AI, whatever it says, I don't accept it. If you can avoid what they call automation bias, whereby you think that what AI says must be right because it looks nice, it sounds very good, it flows, you think it's right. That's why you have the problem. But if you query AI, interrogate it, you do more work, it will take longer. Everything it says, you check it again. What are your sources? Who did you quote? So the way I use AI, I've not had the experience of using material that should be quoted, that should be attributed. Because of the way I use AI, I ask it where it got it from. I go to the original source. And then, for example, my work now, the current work I'm doing, involves a lot of case law research. The cases are Nigerian cases. I have Nigerian wiki law reports from part 1 to the present part, where I'm sitting right now. That is from 1985, before I read law. I bought back issues. So when any case I want, if it's not quoted, I find the alternate parallel citation and go check it. So when I use AI to research, I'm still using the sources. It may be a book, statute. I'm not saying that that's always the case forever, because right now I have some work I'm doing which are all Nigerian case law heavy. I don't know what I will find out when I do work that's not that heavy. So I don't need to put AI. But to answer your question, let me see. I'm looking at my book on citations. I treated how to cite AI if you do use it the way you have said. Okay. I think I have it. Okay, I've seen it. Page 5, 6. If you do use the words of AI, which I will find it strange. Yeah, okay, even if you paraphrase, see the way it's done. ChatGPT, for example, if you use ChatGPT, response to the author's prompt, draft a deep appellate issue from the attached judgment. So now, that shows, even the quotation shows, the sentence shows how a lawyer should think. I have a judgment that is adverse to me. I now want to draft the brief. If you want AI to help you, you go stage by stage. Don't tell it to draft a brief. It will give you stress. So this imaginary researcher said to AI, draft a deep appellate issue from the attached judgment, your attached judgment. OpenAI, 10 August 2029, private AI generated content. That's how you look at your footnote. If you chat with me on WhatsApp, I've given my number in this chat. Feel free to contact me on WhatsApp so I can follow it up. I can actually copy and paste this. It's my own book. I can copy and paste this format for you to look at. Okay? I think that's it about that.
Thank you, sir.
God bless you, Nathaniel. Next person, Wenga is there, and okay, well.
Yes, hello.
Yes.
Okay, good afternoon from Canada here.
Okay, Wenga, how are you doing?
Yes, fine. Asuzu, I'm sure you may not be able to recognize me again.
Okay.
My name is Benga Kigbein.
Okay.
I have a feeling we did our LLM together in 1989, 2000
yeah.
in University of Lagos.
Yes.
Under Professor Adeyemi then and so on.
Yes.
So, and I met you with Laudu Osayin in
Yeah,
Lagos, one of
that's
your
right.
mentees.
Yes.
So this has been a very, very educative, lecture that you have given today, and I know a lot of us must have benefited from it. It's an area that most scholars usually want to dodge because, and it's a very potent research tool. You know,
Yes.
there's this area that I just want you to beam a searchlight on for the
Okay.
benefit of so many people. And that has to do with cross-referencing in
Yes.
research writing. You know, there is this use of the word opposite, there's the
Yes.
use of the word ibit, there's the
Yes.
use of the word supra, which
Yes.
people say is usually for cases alone, and loxit and so on. You know,
Yes.
if you can just explain this area, you know, for the benefit of people, audience, and so on, and
Thank you so much
I
for this
think it will go a
agenda.
long way in
Thank
enriching
you
our knowledge.
very much.
Thank you. Thank
Thanks
you.
a lot. This is a very important topic. And my position is this. I call them Latin gadgets. Drop these Latin gadgets totally from your writing. Now, the first rule of writing is think of the reader. Think of the reader's convenience. So if I'm writing a book, and on page 7, I refer to an authority on the footnotes. And 40 pages later, I say it be opposite. How am I being helpful to the reader? No, I'm not being helpful to the reader. So what we do now, the best way to do it now is to use short form citation for subsequent mentions. The first one, I said, Wole Soyinka, comma, the man died, I put it in parentheses, publisher year 77. Next citation, Soyinka, the man died. Or Soyinka, man died, page. If it's a case, if I say Sheraton Nigeria Limited and Chevron Nigeria Limited, and I want to quote there Sheraton and Chevron, or Sheraton's case in subsequent mentions. Forget Supra. Supra is not helpful to any judge. If you're writing a brief, you quote a case on page 15 and repeat that case on page 30, repeat the name of the case in short form or even full form. Even full form. Unless it's a very long, because you are thinking of the reader. Cross-references in general is bad in legal writing. And if it is statutes, provision, or contract, when you quote a provision of a rule, statute, or contract, put in parentheses what that provision is doing. There's an article I would recommend. I would like everyone to read that article. Let me see if I can find it quickly and paste it in the chat. Very, very useful article that you should read, okay? To see what that lady did. When you go to the article, look at what she did in her footnotes. The way she used parentheticals. Because I've been preaching parentheticals for a long time. That is explaining what a case is doing in parentheses. A case you're not discussing. This lady, for the first time, I found someone who used that for articles. She go to her footnote, see an article she's quoting, she put in parentheses and say what that article is doing. So that will let me know whether I want to read the article at all. I just shared it in the chat. Great writer, Veronica Finkelstein. Start with story, drafting effective briefs. So my answer is minimize cross-referencing in writing. When it's a book or an article or a case, use short form citation for subsequent mentions. First time you name the book or the article or the case, give the full name, full details. Subsequent citation, use short form and then put the new page. Because the first time I mentioned page 37, 977, you say so. If it's a case, you go to the particular judge, you pin cite. So I would ban the Latin gadgets. Ibid, opposite, and supra should be totally banned. Because you want the judge to know what is immediately. When the judge is reading page 17 of a brief, he's not thinking of page 4. So don't make him to drag around and look for where the case is. Thank you so much.
All right. Thank you very, very much for the clarification. I believe that we are excited that we made that choice to listen to you for some more minutes. We are deeply grateful for the insight that you have shared with us tonight. Also, just to mention to you, some of your lessons that you shared with us in the past, they have not left us till today.
Thank you.
There's no point in my life that I will write an email and put, please find attached, because there's nothing for the person to find. And definitely, if I'm attaching documents, there's a need for me to reference those documents that I'm attaching, not just I have attached. I should be able to still list the things that I've been able to attach. So just to tell you that some of these lessons that you have shared with us, you have also been able to cascade it down. So we really appreciate your time. Thank you very much for making tonight very impactful. And to all our mentors who have been on the call, from Canada, Nigeria, across the whole world that are on this platform, we do not take your time for granted. And for everyone that contributed meaningfully to the conversation tonight, thank you very, very much. Particularly Mr. Nathaniel, Mr. Olugbenga Prof. Olugbenga Akpeyin, and Strategic Global Mentor from Canada. Thank you very much for the meaningful contribution, and everyone that's commented in the chat box. I believe this might be a good point to bring the session to a close. Thank you very much, sir. And our mentor extends his kind regards to you. He appreciates you always. Thank you very much for your kindness. Thank you very much, sir. And everyone, let's enjoy the rest of our night.
Thank you.
Sorry, please, before we all leave, please, I urge everyone to please join the group if you're not already on the group. The link to our group is already in the chat box. And also, please endeavor to follow us on all our social media handles. The link also is in the chat box. Thank you very much, and good night.